Welcome to the Docketing Excellence Webinar Series.
Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider that focuses on using technology and automation to provide the highest level of quality available today. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pooled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. To listen to our past webinars or to register for future webinars, go to the tab for Our Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the fourth in the Trademark Docketing series. Today's topic is how docketing fits with your international trademark filing strategies. We've allowed time for questions at the end of the webinar. Questions may be submitted with the question box on the control panel on the right-hand side of your browser window. You can submit a question at any time, but we'll hold the questions in the queue until the end of the presentation. The presenters today are myself, Patty Giuliano, and Ellen Lockwood. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 21 years experience in patent prosecution. I was a partner at the Schwegman Lundberg Wissner firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Patty, can you please tell the audience about your background?
Sure. My name is Patty, as Ann mentioned, and I have been a trademark paralegal for close to 25 years now. I'm on the trademark team here at Schwegman, having traveled to the firm this past year with my attorneys, Pam Hoff and Christy Dent.
Thank you, Patty. Ellen, please tell the audience about your background.
Sure. Hi, this is Ellen. I am also a trademark paralegal. I have about 25 years experience, and I only recently joined the Schwegman firm, and I'm happy to be working with Patty and the attorney team here in San Antonio.
Well, thank you both, Patty and Ellen. Just real quickly, before we get started today, we're going to, Patty's going to give an overview of the foreign filing process for trademarks and have some docketing tips sprinkled throughout that part of the presentation. She's also going to cover some recent changes to the Mexican industrial property law. And then finally, we'll give some examples of specific docket entries to use in the foreign filing process for your trademark applications. So with that, I'm going to hand it over to Patty to get us started.
Sure. Thanks, Ann. Just to get started and to give a little background, as we've mentioned on our past webinars, we're going to be talking today in very general terms about basic trademark basics and the docketing of the trademarks from a paralegal perspective. As we've discussed, generally speaking, the term trademark can be used to refer to both trademarks and service marks, so we're going to be using them interchangeably today, but referencing them as trademarks. For docketing purpose, there is no difference between a trademark and a service mark. And so with that, we'll get started. The foreign filing docket actions after a U.S. filing. One of the first things that should be prompted in your docket when you enter the information for a new filing is the foreign filing priority claim. The Paris Convention allows for filing in foreign countries claiming benefit to the U.S. filing date if that foreign application is filed within 6 months of the U.S. filing date. This can be very important to your clients, especially in first-to-file countries where getting priority back to that U.S. filing date can make the difference in even getting a registration for your mark. While most firms advise the client of the possibility of the foreign filings, a lot of clients don't really drill down into the report out for the filing and kind of glaze over that. So even if you say you claim no responsibility for reminding them again, most clients appreciate the courtesy reminder. But it's important that you set up your reminder so the date doesn't sneak up on you. Typically, 1 month is enough, but depending on how big the corporation or big the company is, your client may need to ask more than one person, and you might have to go back to the product manager and possibly the marketing people to find out how broad and how far-reaching the product is going to be marketed. So it might, in some cases, be that 2 months is a better option. I like to err on the side of caution and give everyone 2 months just in case. If your client is a foreign corporation or has offices worldwide, another option is issue is that your filings may actually begin outside the U.S. And if so, you'll want to first confirm that that country is a party to the Paris Convention. Very few are not. As the 6 months may then be calculated in reverse. In other words, from that foreign filing date to the U.S., so you could claim U.S. benefit in the U.S. to that foreign filing date. However, you will need to be prepared to offer a statement to the USPTO that the company has a real and effective office in the country of origin to avoid problems. We've actually had that happen a couple of times recently where we have had a foreign application come into the U.S. claiming priority to the foreign filing date, and the examiner recognizes the name of the applicant as a huge corporation here in the United States and has questioned whether or not that entity actually has a valid claim coming into the United States from outside. And in both cases, I'm happy to say we were able to enter that statement, so we didn't have to lose our priority. Another thing that talking about that the foreign filing date launches when you file a new application is that foreign filing priority claim may not apply to every single new filing. Generally speaking, if a mark has been registered anywhere for the same goods and or services, then you cannot claim priority again. However, if you're expanding the description or filing for different goods or services, then you may be able to claim priority on that second application. With regard to timing, due to the time differences, you need to be sure that you have instructions at least 3 days in advance, if not more. Asia, Pan-Asia, Australia, New Zealand, very popular foreign filing options, and they're a full day or more ahead of us. So you need to have that information as soon as possible. And also another issue with getting your instructions at the last minute is that there are a number of countries, Middle East countries, some African countries, that you absolutely cannot even file without the original documents, and sometimes those have to have legalization before you file, which you obviously can't do at the last minute because Middle East legalization or Chinese legalization can take weeks. As far as China, they can usually file with a copy of a power of attorney, but they need at least an advanced copy of the signed power of attorney. So that's going to take you a little time to get that from your client and get it over to the foreign associate by that deadline. A couple of docketing tips that I've kind of already mentioned in my comments, but just to go back over a little bit on the next slide, is that to be sure, we've talked about this in prior webinars, is that when you're setting up your matter in your docket system, make sure that you're setting it up as a trademark, and to be sure that that priority is docketed as a 6 months, because as you know, the patent priority is 1 year. Again, you want to secure your instructions as soon as possible because of time differences and potential documentation requirements. And something we have found here is we usually keep that 6-month deadline open until the very end. Unless the client tells us absolutely no way, we're not ever going outside the United States, take it off your docket. A couple of scenarios that have happened to us over the years is, you'll tell a client what it costs to file in foreign countries, and they'll say, oh, no, we can't afford that. That's outside our budgetary, we have budgetary limitations. And the next thing you know, they're contacting us saying, oh, we pulled together some money because we realized the value of these filings. We didn't have to contact them again, but it made it easier for us to go back in and see where our deadlines were and how much time we had left. We've also had clients who file they'll find the foreign applications either with the U.S. or shortly after, and maybe they'll only file in 1 or 2 countries. They're kind of testing the waters just to see how the mark is being received in foreign countries, in the foreign country trademark offices. And if things look like they're going well, they may kind of give us the go-ahead and file in all our Tier 1 countries, or Tier 1 and Tier 2, and they'll let us know by the end. Those are usually conversations we have with the client along the way, and we can make notations in our, I keep saying FIP record, but in your docketing record, so that you'll know how to go back to your client and what you need to get from them to move forward. There are a lot of other reasons as well why you might want to keep that date alive until the end.
Patty, this is Ellen. I had a question. What do you recommend? Do you recommend still docketing to 6 months and sending out a reminder notice to the client when the client has no operations outside the country? Maybe they've told you that they never, ever, ever want to file outside the country. Like it's a smaller organization maybe, or just there's some way that that the chances are very, very high that they're never going to want a foreign file. Do you still docket those deadlines and send out the reminders to the clients?
We do, because in the world we live in that is so electronic, depending on what the goods are, even though a client says, we're only marketing here, they might find out at some point that they have someone in the UK or someone in Canada or someone in Mexico that has become interested. So you can see that your product or your service, the word is getting out. And it could be at that point that they want to consider, just maybe some foreign filings, but it is also incumbent upon us to at least remind the client of their options during the entire prosecution, even if we kind of know, you can word that in your email to them or your contact with them as we think you don't have any interest here, but please confirm. That way we've handled the things and taken care of the reminders that we need to do.
Thanks.
Another thing to remember when you're filing in foreign countries, aside from Canada and a couple of other countries, not very many, use is not required to get a foreign registration. In some countries, Canada, Mexico, and a few others, you have to actually declare whether you have use. But in Canada, you do have to prove your use unless you're claiming priority to U.S. and use in the U.S. But that's a whole nother topic that we're not getting into here. But even if you get a registration based upon your intent to use, you have to remind the client that the registration can become vulnerable to non-use cancellations after a period of time if they don't put it into use. With the exception, I believe, of Chile. In Chile, you don't ever have to show that your mark is in use. But in other countries, you'll want to make sure that your docketing system launches soft use or proof of use deadlines. These are not the same as like an affidavit of use in the U.S. or in the Philippines or some other countries where it's actually a hard deadline, and if you don't prove up your use, you're going to lose your registration. Here we're talking about soft use deadlines, not hard deadlines. That said, they can be just as important as they alert the client to the potential for non-use cancellation actions. Some countries it's 3 years, and some countries it's 5. But if a mark is really important to the client and they're still trying to finalize their contracts with the distributors, or if they're working with marketing on that country's strategy, when the time period comes up, you can always file a fresh application to restart that protected period. The downside is that some countries make you expressly abandon the earlier registration if you file for exactly the same mark and the same goods. But if third-party actions are a concern, refiling is probably your best option. Another option is you can refile and file for slightly different goods or services. This is best discussed with your foreign agent, your foreign associate in that country to see how you can refile, the potential for refiling, still protecting your client's core goods and services. But there are a number of issues you'll want to consider before doing that. So again, it's something you want to talk with your foreign associate before you do that. So now that we have discussed some general filing, foreign filing issues, I want to discuss just a few foreign filing strategies. For example, if your client just wants to go into one or two countries of interest, common choices are Canada, Mexico, China, the EU, like I said earlier, Australia, New Zealand are very popular first steps into foreign protection. If you're just choosing one or two of those, it's often that we'll just go directly into that country with our foreign associate and file there. Of course, if you're going into the EU, that covers all 28 countries of the EU, including the UK for now. Or you could choose to file in Madrid. In Madrid, there are a number of countries you could add, and the cost depends on which countries and how many you choose. The Madrid is processed through WIPO, and it must be based upon an existing application or registration. And that filing is going to be known as your base application or base registration. And the application or registration must be pending in a country that is party to the protocol. So for example, Canada is not currently a contracting party, so your Madrid could not be based upon a Canadian application or registration. I've been told that Canada's working on it, they just kind of aren't there yet. In the EU, again, like I had mentioned on the EUTM, it's one registration, 28 countries, no contact with individual countries. Backing up a little bit to the Madrid, you do end up with a statement of grant of protection in each country that you choose in your Madrid application, which is slightly different. However, the EU is like one entity, and it is not broken out, whereas the Madrid, you can have different protection in each country. It's not uncommon for China or Japan to come back and ask for amendments to the descriptions of goods. And they may not use, so your description may be different in that same Madrid if you're in China than it may be in, say, Spain or some other country that you may choose under your Madrid application. Ellen, you had something you wanted to add here, correct?
Right.
When you were in-house, yes.
Right. I was recently, I just came from working for a large international corporation, and we prosecuted it, I had our own trademark prosecution in-house. And so we dealt with, of course, foreign associates, just as everyone else does, to file our foreign filings. And we rarely used a Madrid application because of the countries we chose. But when we did, we would generally file, keep those docket dates, just let our foreign associate keep up with those docket dates. As far as initially, we would, when they would notify us this is dates coming up, we would add it in. And of course, if you're using a docketing system, as we were, a lot of those dates are going to automatically come in once you open the matter and put in the particulars for the application. But we kind of used our docketing system for foreign filings and Madrid filings almost as a backup to what our foreign associates are doing. It was their primary responsibility as the attorneys that were prosecuting the applications to keep up with those deadlines, and we used ours as a follow-up. I rarely had to follow up. I think maybe twice in 17 years did I ever have to ask, hey, whatever happened with this? But generally speaking, we relied on our foreign associates to keep track of those deadlines, and ours was just a backup system for those.
And Ellen,
well, that's a great.
Yeah.
Oh, go ahead. Go ahead, Patty.
No, I was just going to say, to expound on what she's saying, that's one of the things that comes up when we talk to clients about the foreign associate recommendations. And so many times we get a recommendation from the foreign associate, but they're going in this case directly to Ellen, and she has, the company's overall view of what they're trying to do in mind when they give her instructions. Some people say, you get the foreign associate instructions, you just do whatever they say, which is not always the best case because the foreign associates don't necessarily know the client strategy worldwide. And sometimes they want to enter statements or recommend entering statements or making amendments that might be contrary to something you're doing in another jurisdiction. So that's always an important thing to keep in mind when you're looking with working with your foreign associates, that not just blindly follow their recommendations.
Patty, I think that's absolutely true, because I know I worked on applications where the examiner would come back and would object to our priority applications wording of goods and services and would suggest something else that in many cases was completely inappropriate, did not at all describe our goods and services accurately. And so we had to work carefully to review those and then to exchange correspondence back and forth with our foreign associate so we could get something that the associate believed would work with the local trademark office and that we believe was an accurate reflection of our goods and services. So you're absolutely right. Just because a foreign associate recommends something or suggests something does not mean you should automatically agree to it, whether you're working in-house or working for an outside firm that's assisting other clients.
Yes.
Well, thank you, Ellen and Patty. I have a question with respect to how you track the Madrid or the EUTM applications. You know, I'm more familiar with the patent records, and I think about a PCT application where in a docketing system you start with a single record for the PCT matter, and then when you file your applications, your national stage applications in individual countries, you have separate records for those individual countries opened up in the docketing system as well to track the docketing in the individual countries. How does that work for Madrid applications or EUTM applications? What do you open up, and how do you organize the records in the docketing system?
Oh, sure. For the EUTM, that's easy. It is a jurisdictional registration. So we open up an EUTM record, and it covers all of them, because you can't separate them out without filing a separate application. You could pull one out, but it wouldn't really do you any good. If your EUTM application fails, you can file in certain different countries, but there would be no benefit to opening up additional matters to the EUTM initial matter, except to just confuse everyone. And I have seen it done. We had a client transferred in all their files to us, and the other firm had listed each one of the EUTMs separately. And then I was looking at the exhibit, and I thought they all have the same number. Of course, it's a similar thing to the Madrid, but it was for these European countries. We realized right away it was really a EUTM registration and not a Spanish registration, because you can't renew it in Spain anyway. Conversely, the Madrid, we do very similar to what you were talking about here at this firm, is that we open up, you have the base home application or home registration, the base, and that is one file. And then you open up a new matter that is going to be the IB file, the WIPO file. That is where we are going to docket the date we have to renew and the registration number. And it's also going to be the main, I'm trying to think of how we word them here. It's like the main file, but then we open up separate country matters for each one of those countries where we've claimed extension under the Madrid Protocol, and those are all considered to be part of the main file, so they don't stand off on their own. They have a PROT code after them, like they're protected under the WIPO. I'm not really sure what PROT means, but it's all part of the same record, but yet since they do issue individual statements of grant of protection, and you can also get a rejection. So each one of those country records is very important to be able to mark when they registered, if they registered, and also back to the soft use deadlines, you'll want to make sure your soft use deadlines are listed in each one of those countries, because again, even though it's under a Madrid, it is considered to be somewhat of a country level registration that can be vulnerable to cancellation if it's not in use, and someone could come in and cancel that country extension based on your non-use. So it's similar to the PCT in that respect, is that you do have the individual countries in your as a separate record, as opposed to the EUTM that is just one record.
Okay, well, thank you for clarifying that.
Another one of the areas we want to talk about is the Andean Pact. The Andean Pact currently has 4 member countries. Previously, Venezuela was a member, but they abruptly dropped out. But now you have protection. You can get protection in Bolivia, Colombia, Ecuador, and Peru. The main consideration here is that these are all separate country registrations. But under the Andean Pact, you can use one of the registrations, a registration in any one of these member countries to support your use in any one of the 4 countries. This has come in handy in infringement disputes and non-use cancellation actions. If you have only a registration in Colombia and somebody is questioning you in another one of those countries, you are protected under the other registration. But no, just to be sure that I'm not misspeaking, there is not a common registration. You do have to file in each one of the 4 countries. Sometimes we have recommended to our clients if budgets are tight or something of that nature that they only want to file in one of those 4 countries, which is something you can do. Obviously, you want to recommend filing in all 4 if it's possible. However, if it's a secondary mark or, you might just, one of the countries might be sufficient, and then you can rely on the flow-through, kind of the flow-through concept with common law. The only other thing that I would say about docketing here is that if you want to mark the records as related or otherwise make a notation about the connection, it could be very helpful, because when you first get something that says someone is challenging your registration, when someone looks and sees that this is an Andean Pact registration, it's, oh, okay, then we might be okay. Let's check our our use in Colombia to see if we can avoid getting this Bolivian registration canceled. So it's just kind of a good reminder to people who might not have those things on top of mind in these countries. And then another one we want, yeah, I'm sorry, go ahead.
Oh, go ahead. I wanted to quick ask a question on Andean Pact to make sure I have this right. So it's interesting to me, thinking about this from the standpoint of how you organize the matters for docketing. And you have to think about, I guess, whether you have a common registration or not. So tell me if this is correct. If you have an EUTM application, you just have one common record in the docketing system because it's one common registration. If you have a Madrid application, you have typically that one common registration for the or you have a record for that one common registration, plus then you'll have records for the individual countries. And then for the Andean Pact, you only have the individual countries in the system because there is no common registration between them, right?
Correct. That is correct.
So it's very important for
for docketing purposes. There's no common registration or any other connection other than this pact that the countries entered into, which allows use in one country to support registration in any of the 4.
So for someone who's setting up or opening files in a docketing system, it's important that they know these different filing strategies that you're talking about so they set the records up correctly to reflect that, right?
Right. They could just make a note in the record that it's an Andean Pact country if they're aware of that, because that would be the only difference in the docketing.
Okay, good.
It just would be an alert for anyone looking at the record. Going back to what we were talking a moment ago with the EUTM, similarly, the OAPI is a multi-jurisdictional filing option. It's only done very seldomly. I've only filed one in my entire 25 years, but I've seen several. I've had to renew a few. So it's a kind of an interesting concept. The countries are not they're not on top of mind for most people when they're looking for foreign protection. But if you have something that is going to the African continent, this would be something that would give you an option for protecting in all of these countries under one umbrella registration. And some of these countries are so small that it would be really difficult to go in and get effective counsel in some of them. Some of these countries even still do paper filings, and they don't even have any electronic records. And the OAPI is responsible for making sure that all of the information is correct. And we have had this issue on the African continent before, where you're just trying to find somebody in some of these little bitty countries, little jurisdictions, who can help you. And, you know, it might just be some woman working out of her home. It's very odd, and then you may never hear from her again after you send her money. So, and I'm not saying that's the case across the board, but, you know, some of the countries are so small that it has been rampant with some abuse in that fashion. Interestingly enough, the OAPI is part of the Madrid, which we'll talk about a little bit more and further in a slide, because the OAPI has quite a few documentation requirements, and if you file into the Madrid, you don't have to meet all of those steps. You don't have to designate individual countries like you do in the Madrid. Again, similarly to the EUTM, it's just one size fits all. You get all of them or none of them.
Okay. Well, you said you had done one of these in 25 years, so I'm curious what the experience is with the rest of the audience. So I'd like to take a poll real fast. Take a minute here to ask a question in the box on your screen. Does your organization file OAPI applications? Yes? No? No, but we have our outside counsel do it, or you don't know? So we'll give everybody a minute here to answer. All right, just a few more seconds. Okay. So here's the results. 9% of the audience has filed OAPI applications. 60% has not. 7% uses their outside counsel to file them, and 23% don't know. So about 16% are either doing them themselves or through an outside counsel to do them. So they are certainly
higher than I thought. Yeah.
Yeah, me too. And it's something that you need to be aware of for docketing purposes.
Interesting. Very interesting.
All right, so let's go back
to
the slides. Did you hit on the docketing tips for OAPI?
I think we did a little bit, but just really nothing special. Just to be sure all the countries are current that are in your docket systems template, to make sure that all these countries are included in there. So if you ever had to do a report, you could go back and see what countries are actually protected under an OAPI registration.
Okay.
We want to talk a little bit about Mexico. It's not really one of those ones that's unusual. A lot of filings in Mexico, but there have been a lot of chatter recently because they passed some new amendments to the trademark, the industrial property law. We've been told that they will go into effect 60 days after publication, but as of about a week and a half ago, I don't think they had been published yet. But when they are published, we'll all need to make sure we update our docketing system. Because the biggest change from a docketing and maintenance perspective is that registrants will be required to file affidavits of use. Up until now, we treated it as though it was a soft use deadline. We advised the clients of the vulnerability of the registration because you're now outside your protected period after registration. And if they weren't using it, many times we would refile because Mexico is such a big part of most U.S. companies' marketing schemes. But if now we will have to file the affidavit of use. So your options will be file the affidavit of use or file a new application, because if you don't file the affidavit of use, your registration could be canceled. Similar to the Section 8 in the U.S., it's going to be a required filing. Another thing that is changing in Mexico is from a filing perspective. In the past, we just had to tell them if the mark was in use. and that's all. You didn't have to claim a date. You just had to say if it was in use. And now we're going to actually have to claim a date of first use. If you do not claim a date of first use and you file based on an intent to use, the way we read the rule is that you will not be able to go to claim a date of first use prior to your filing date. It will be an affirmative declaration that your mark is not in use. That's why you're filing it as an ITU. And so in the event that you get a challenge at some point, your filing date will be the absolute earliest date you'll be able to track back to. Again, that's how we read the rule at this point, and our foreign associate has kind of confirmed that to us. It's not like Canada at this point, that at least that we understand. In Canada, if you claim that the mark is not in use, and then you later claim that it is in use, your Canadian registration can actually be vulnerable to cancellation based on it could kill the registration. But we're not understanding that Mexico will be that way. We're just understanding that it will be how far back you can claim your date of first use. There are several nuances in this new amendment, including the concept of secondary meaning has been introduced in Mexico, and the ability to rely on coexistence agreements. You can now claim bad faith if you're trying to seek invalidation of a registration or oppose an application. And another issue that has been brought up in the amendments is that sound and smell marks will be introduced into the registry, previously not. The biggest docketing tip here from my perspective is the change of the proof of use, soft use deadline to an affidavit of use hard deadline. I assume that most docketing systems will run some kind of update as soon as the Mexican amendments go live. But you'll just want to be sure that whoever is the docketing administrator for your firm or your office, that you make sure that those are run to be sure that those dates are updated and show as, and when they show as being a hard deadline as opposed to a soft deadline.
Patty?
Well,
I'm sorry.
Go ahead, Ellen.
I was just going to ask a question. Patty, do you know if these rules are going to apply to only registrations that are marks that are registered after the rules go into effect, or will it apply to existing registrations as well?
The way we read the rules, it's not going to be retroactive, if that's what you're asking.
Okay. Right. Okay. So it's only marks that achieve registration after whether they're pending or filed after the rules go into effect.
That's my understanding, but I would have to double check that.
Okay. I was just curious. It's just something to think about. So, all right. Thank you.
Yeah,
great question. Go ahead, Patty.
Okay, well, I was just going to move on to Brexit because everyone loves that, everyone's favorite word. It's, I think it's in every branch of business these days, and certainly it's a big deal in IP. When we were at ENTA a couple of weeks ago, we talked to two different of our foreign associates, and both of them told us the same thing, that everyone's still shaking their head. There's still so many gray areas. They cannot really give us any final word on a number of matters, a number of issues that are going to face trademark owners, but they are certain about a couple of different things. They are certain that the EU registrations will be grandfathered and made equivalent in the UK. And they also said that they are certain that there will be a period of time for applications that are pending in the EU on March 30th, that those applications will have the ability to be transitioned to the UK, so no priority is lost. We don't know what or if fees will be involved to get those, to transform the registrations and applications to the UK registry, but it's highly unlikely that it will be free. And since it is highly unlikely that it'll be free, and we're getting so close to the deadline, we have started recommending that clients go ahead and file in the EU and the UK going forward, because we are getting close to that deadline. And that way you can avoid all the chaos that is for sure going to happen as we get closer, and getting everything transitioned over. And I don't even know what the period of time is going to be that it's going to take them to get everything transitioned over at the end. So as far as docketing tips, we don't really have any tips to offer yet because there's nothing that's concrete. Won't have anything until the agreement is actually signed. But as soon as that agreement is signed, there will be a flurry of activity for trademark owners, trademark practitioners, and docketing software programmers, that's for sure. Again, as we say in this slide, your best resource is your foreign counsel. We have been in touch with ours, and like I said, at INTA, we met with 2 different ones just to be sure there weren't multiple options that we were missing. So just stay tuned. Another thing we want to just kind of talk about briefly, because it is such a big thing with foreign filings, is ancillary formal documents. Your certified powers of certified applications, your powers of attorney. In certain countries, you need certificates of incorporation. Lots and lots of documents in some countries. It's hard to follow them if you've got a bunch of if you file in clients tier 1 and tier 2 countries, and each country has their own requirements, and some have to be legalized, some just need to be witnessed, some need to be, you just need an apostille. There's just so many little things that happen during that period of time. Ann always kind of ribs me a little bit on this. I'm all about the status check, and I will have multiple status checks in all my records, because I want to follow the path of my documents to make sure nothing gets lost, because these are usually hard deadlines. Usually get 3 months, some countries more, but typically 3 months is your deadline. But depending on how far the legalization has to go, it can take a while. And so you'll need to be sure you have multiple status checks to be sure you're able to check them off when they go to your client, when they come back from your client, when they go to your service. And then, they have to be, whether they need an apostille, if they need to go to the consulate, and then they need to get to your foreign associate by the deadline. As I mentioned, I use a service for legalization because it just makes it so much easier and deadlines more predictable. Years ago, I tried to do it myself, and, I sent to a Chinese consulate a check for $1 too little. They sent everything back to me, and I had to get a whole new check issued and send it back up there. Just 2 months ago, I sent something to my service even, and I thought I was being real proactive and I was going to help. So I filled out that Chinese G1 that we all have to do when you need legalization in China. And she said, "Oh, this form just changed last week." I'm like, "Of course it did." And if I had sent it off to the Chinese consulate, that would have slowed my documents down by at least 2 weeks, because by the time they got it, they reviewed it and sent it back to me. And you just don't have that kind of time. So we have just decided here that the best thing to do is leave that to the professionals. They know what all the requirements are, and they know people there. As Ellen has comments on this, because she has an experience with legalization as well.
Right. It's as Patty says, we always use, even when I was with a corporation, we always use the service, because you just can't, like Patty says, it's their business. And so we would let our contact know what we needed, send off the documents. They have the advantage of their personnel going to these consular offices on a regular basis. So everyone knows each other. The personnel from the service knows the folks that they're dealing with at the consulate's office, and vice versa. And if there's a minor issue, it's much easier to fix with someone who's standing right there, who can run back to the office and, as like Patty mentioned, get another $1, or get another form filled out if it just changed, or maybe even a consular employee would be willing to let something slide for once because they know that they deal with this person on a regular basis. You just can't have that relationship with all these consulate offices, and it's not going to be, as Patty says, an efficient use of your time. Any couple of dollars you might save is not going to be worth it. I've found that these services charge a very reasonable fee, in my opinion, to do all of this for you. And I think those personal relationships they have and the fact that they are face-to-face with these folks is invaluable.
Well, that's great advice, Ellen. The next thing I have is a couple of slides just with some example docket entries. These happen to be from Foundation IP, but you could envision what the similar language would be in other docketing systems. So the first slide is looking at what gets docketed in the U.S. record when you file a U.S. trademark application in order to track your foreign filing deadlines. In this case, after that U.S. application is filed, this docket system launches a deadline for a e-filing receipt expected, and then a status check at 3 months, and then reminders for that foreign or counterpart filing beginning 3 months before that 6-month deadline, 2 months before the deadline, 1 month before the deadline, and then finally the final deadline on that date that's 6 months after your U.S. filing date. And the timing of the reminders and the amount of reminders that you put on your docket may vary based on your organization. And Patty talked about kind of different preferences and for how often and when you should have those reminders. That's a stylistic thing, and that will vary. But this is just to give you the example of what that might look like with reminders coming 3 months before the final deadline, and then the final deadline on the docket. Now, let's take a look at the corresponding docket entries in the individual foreign matters. So in this example, let's say you've decided to file the application in China, or no, let's say Canada. You've decided to file in Canada. This would be the example of the docket entries that would show up in the foreign record in Foundation IP after you have entered that the instructions were forwarded to the foreign agent for filing. So once that event takes place in Foundation IP, just as an example, that's a docket entry that you can add and track in that system. When that activity is added, it will launch the things that we're looking at here. So it will launch a deadline for a status check, a filing receipt, the agent confirming filing of the application, the agent acknowledging receipt of the instructions to file, and then the ultimate foreign counterpart filing deadline. And for those of you who may be Foundation IP users, the activity code for this is APAS, if you wanted to know what that is. Ellen or Patty, any comments on these example docket entries? It's certainly not the only way to do it, and systems will vary in terms of the language that they use and the types of docket entries that they use. These are just provided as examples, but any comments from either of you?
I would like to comment on this APAS docket here, because I came from a PATSI system, and there wasn't an opportunity set up in the system where you could enter that you'd sent something to the foreign agent. You would just have to, the date mailed is what we had. And it didn't launch, because to me, one of the most important, or two of the most important that are on here, is the foreign associate acknowledges receipt of instructions. If they don't acknowledge that they got them, then I just assume they didn't, and I will follow up with them. But if I'm waiting, and then the foreign counterpart filing is the ultimate deadline, so those should be the same. Well, they're not going to be the same date, but this acknowledgement should be within a couple of days of sending it off, and that is one of the most important dates on there, to be sure that just because you mailed it doesn't mean they got it, or even that they're doing anything with it and they've looked at it. So to me, that's one of the most important, and I think that is from Foundation IP, coming from PATSI, that's one of my favorite docket items. We do a lot of foreign filings.
Great. Any additional comments, Ellen?
No, I just think that what both of you said is true, that you need plenty of reminders. You need to not assume that things are done until they're done, and you have confirmation that they're done. And I think most filing systems give you some options to have some flexibility. So if there is some deadline that you feel is important to you, that just because it's not offered automatically by the docketing system doesn't mean you can't add it and that you shouldn't add it. That's certainly better than relying on, I'll just keep this email in my inbox as a reminder, or I'll try to make a note of my calendar, or the one that never works for me, I'm sure I'll remember to check on that. That just never seems to work for me. So I would certainly agree that better to have too many docketing action items to mark off than too few.
Yes.
Yeah, and it is a very good idea to get those dates on a docket where they're tracked and where everybody can see them. I am always surprised in my role at Black Hills IP at the number of people I talk to who manage things through just emails, and there's a lot of potential for error there. So it's a best practice.
It really is.
Those dates on a docket and tracked somehow so they're out of your email systems. Well, I just want to remind everybody that you can submit questions in the question box on the control panel on your screen. If you have questions about Black Hills IP services or processes, there'll be I think there's an opportunity with a questionnaire that pops up at the end of this program, and you could request that somebody contact you, or you can contact Jim Brophy. His contact information is right here. He's our Vice President of Sales. I have a couple of questions. One is, what are the names of the outside service providers that you currently use to process legalizing the documents? That came from one of the listeners. Can you give any?
I use Capital Services. I believe they have offices around the United States and in the capitals of most states in the United States, and we have found them to be very reliable. I'm in Texas, so I send everything that I have to Austin, and they get it to wherever it needs to go. If I'm on a short timeline, I can contact Geneva, my person, and say, I need this to be legalized immediately, and the notary is in California. She says, here's my person, send it there. She will handle all the contact in between, and I've found them to be very, very reliable, very efficient, and very cost-effective.
Great.
I agree, and like I said, and over the years, I've used a couple of different services in the past, not because Patty uses it, but I also have used Capital Services. I think that whomever you use, if you're going to start using a new service, do get recommendations from other people in the field as to whom they are using and what their experiences have been. Do shop around for pricing. Do ask someone, a company you're considering, if they have anyone that you could speak to that's used their service. I think those things are very helpful, because it's just too important to just do on a whim, or to, I'll just spin the little Rolodex here, for those of you older remember what that is, and try this new company that sent me something on this, and now I've got a very urgent matter, and I'm hoping that this company comes through for me. That's not when you try a new company. So.
Right. Well, a couple more questions. I didn't give any examples of docketing deadlines for those ancillary formal documents, but obviously, as you said, that's an important part of the foreign filing process. So how do you docket those? Are those launched off of a filing date? Are they docketed off of agent letters? Can either of you comment on how you track the deadlines for those formal documents?
Typically, what happens when the foreign associate sends a confirmation of filing, if they have requirements that we don't know about, or even if we do know about, they will say what the deadline is in the filing confirmation. And when we docket the information, the application number and the filing date, et cetera, that priority document deadline will also be docketed in your record. As I said before, I usually go and add additional personal status checks, and I do that in the docket as opposed to my personal calendar, because you never know what's going to happen tomorrow, and I want other people to see, have access to all that information. And so I put manual status checks to get it back from my client, a manual status check to get it back from my service. in addition to the formal docketed priority document deadline that's in the docket from the original correspondence from the foreign associate.
Okay, good. Ellen, I have a question for you. I know you were in a corporation for a long time before you came to the Schwegman firm. Did you do anything different with respect to the docketing for foreign filings when you were in a corporation versus what Patty's described here?
Not generally speaking. I would say that the only differences would be, and I think this is true though for everyone, is as you know your client, or in the case when you're working in a corporation, your business units is trying to learn what those business units or clients' processes are for approvals, for getting back to you with information, those kinds of things, because very often your contact is not the final person who has to sign off or weigh in or make a decision. And so allowing yourself plenty of time to be sure that you get that information and make sure that the client or business people understand, for example, that going to need things well in advance if you're going to have to, as Patty pointed out, get lots of ancillary documents just to be able to file the application, as opposed to ones that can be provided within a few months after the filing. Dealing with time differences. If your client tells you, hey, it's 4 p.m. Central Time in the U.S. and we would like this filed today with today's date in Australia, well, that's not happening. It's already tomorrow in Australia. So just getting to know your clients and finding a way to provide the kinds of reminders they need to help them get you their instructions in enough time for you to get the filings done for them, I think is important. And that's, of course, one of our jobs, is to know our clients and to work with them.
So even though it was a different environment, it sounds like it's the same challenges and the same best practices then, whether you are managing the prosecution of a trademark portfolio in a law firm or managing it in a corporation where you're doing the work in-house.
Absolutely, and like I said, some business units, it was the same person who was the contact, was the person who was making all the decisions, and in some other business units, it seemed as if no one wanted to make a decision, and they would pass the question around to many people, and it often took a long time to get a response. So,
great. Well, Patty and Ellen, thank you so much for sharing all of your experience with the audience today. I just want to mention the next webinar that's coming up. In the Docketing Excellence series, we have other webinars on other topics that we do, but the next one in our Docketing series is next month on July 11th at 1 p.m. Central Time. The topic is what to expect when docketing TTAB opposition and cancellation proceedings. To register for this webinar, go to the tab on our website for our educational resources. Scroll down towards the bottom of that page and it will have the list of upcoming live webinars, and you'll be able to register right there from the website. I'd like to thank everyone for participating today. We hope you will join us for this upcoming webinar on TTAB docketing and also other webinars in the Docketing Excellence series. Thank you very much. Have a great afternoon.
Thank you, Ann. Bye.
Bye-bye.